Okay, we're on the record in People versus Hackney. This is file number 256807. The record should reflect Mr. Hackney's present here in the courtroom today. If I can have counsel put your appearances on.
Good afternoon, Your Honor. For the record, Michael on behalf of the people.
Larry Brown on behalf of Mr. Hackney.
Okay, we're on the record today. At sentencing in this case, the court indicated that it would set restitution review hearings every 6 months. And so Mr. Rolla, it looks like I had the clerk take a look and you can confirm for me whether this is accurate from your side of things, but since the sentencing date in May, and including, I think, 2 payments in the last week, is that right?
Yeah.
Today. Okay, Mr. Hackney has paid $350, which most or all of that's required to go towards statutory costs before it can be applied to restitution. Is that your right?
Yeah, so mine said like $174, $140 went towards the restitution amount, other than the payment. And it's my understanding that was made this morning because as of last Friday, there hadn't been payments made according to the check number amounts.
Okay, Mr. Brown, is that the information you have as well?
That is the information. I was discussing it with Ms. Davis and Mr. Rolla as we came in today. So, and I did speak with Mr. Hackney. He said he was going to be making payments.
Okay, so Mr. Hackney, aside from today, you haven't made any payments since May.
Yeah, I was moving and had a couple deaths in the family and all that stuff, and said fiance lost her job, and so it was tough for a minute. Now we're back on track, and I talked to my PO this morning and said that I'll be able to, every 2 weeks, I'll be able to make a $150 payment on that.
Okay.
To moving forward.
So as you know, I held 9 months of jail in abeyance. And the purpose of that was so that you could work on paying restitution.
Yes.
If you're not paying the restitution, then I'm going to put you in jail. I mean, there's no reason not to. That's the only reason why I didn't put you in jail in the first place. What you're describing to me is life, right? Things that get away. The people that are owed this money have things going on in their lives that they could probably use the money that you owe them, right?
Yes.
Same thing. Your situation is no more justifiable than theirs. So I'm going to set this for another hearing in 3 months.
Okay.
If we're back here in 3 months and it's a situation like today where you've made a couple payments the day of that hearing because you know the hearing's coming up, then you're going to go to jail that day. So unless there's been some substantial progress made on paying back this restitution in the next 3 months with regular payments at regular intervals, then you need to come to court planning on heading to jail. Okay.
Okay.
Do you have any questions about that?
I agree.
Thank you. That's all
Thank you.
People versus Dofer, case number 256895 and 6896.
Record, Your Honor, Michael on behalf of the people.
Larry Brown on behalf of Mr. Doper, who is currently lodged.
See an RJ. Yeah.
Yes.
Oh, can one of you guys give them a call and just have them get on Zoom? For some reason, I thought he was out.
I think his bond was revoked, Your Honor.
Okay.
Right, so can you go for on the Zoom? Oh, who's in the line? Okay, he's doing a few people. Right. Yes. Yeah, maybe in between before it takes another one. Think you can do that? Okay. Method is what you call it. Okay, okay. Okay, thank you much. So. A bunch of rain, so we're trying to tap.
We'll take a short break. Can you just kind of
I'll keep an eye on it.
Hey, it's not raining at the moment.
Hello?
All right, Mr. Dofer, can you hear me okay?
Yes, sir.
Okay, we're on the record in People versus Dofer file number 256895 and 6896. The record should reflect Mr. Dofer's present today by video from Otsego County Jail. If I could have counsel put your appearances on.
The record, Your Honor, Michael, on behalf of the people, Larry Brown, on behalf of Mr. Dover.
Okay, Mr. Brown, how did we want to proceed on Mr. Dofer's files today?
Your Honor, I spoke with him a couple of days ago, or perhaps even just yesterday. There has been a plea offer made in this matter in which he would plead to count one in each of the felony files for dismissal of the habituals, as well as dismissal of the two misdemeanor traffic files.
And the remaining counts of the two felony files.
Yes, Your Honor, and the remaining files. I did go over that with Mr. Doper. I went over the exact things, the possession of brass knuckles. There's one file with 3 counts of R and O. It would be dismissed 2 counts, pleaded 1 count. He did not seem to understand that. I'm not really sure what he didn't understand, but that has been the offer. I did go over it with him multiple times. So I really am not quite sure what he wants to do today. He said he wanted to plead, but then he would ask me what he was pleading to.
All right, Mr. Dofer, were you able to hear what the terms of the plea offer are?
Yes.
Did you want to go forward with that plea agreement today?
Yes.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Dofer, are you currently on any kind of probation or parole?
No, sir.
All right. In file number 256895, you'd be pleading guilty to one count of possession of metallic knuckles. That's a felony that carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine and mandatory forfeiture of that weapon. Do you understand that?
Yes, sir.
And then in file number 256896, you'd be pleading guilty to one count of resisting or obstructing. That's a felony that carries with it a maximum penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, sir.
And then in exchange for a guilty plea to each of those counts, the prosecutor is indicating that he would dismiss all other charges in both files that are pending. Do you understand that?
Yes, sir.
Do you have any questions about that plea agreement at all?
I don't know. I was just really confused because like what we're talking about now is not like what I understood. What I understood is that I was going to be pleading guilty to the domestic violence in return that I wouldn't be an habitual and that we would be dropping all the driving offenses. I'd be pleading guilty to the brass knuckles, but that'd be on a different date. In that I would be pleading guilty to 2 hour and hose.
Judge, perhaps I can maybe clarify that there is a separate domestic violence case. Ms. Brooker made a plea in that case that if the defendant pled, he would qualify under 769-4A. That was separate and apart from the 2 felony files. And again, in addition to the other charges being dismissed, people were also dismissing the habitual offender enhancement.
Okay.
Right, but that domestic violence case is still its own thing with its own deal.
It was a separate matter. Mr. Brown and I discussed it. There was a request that it be dismissed. But as that matter, I haven't had an opportunity to speak to the victim on that yet. That's a separate matter from this felony cases. But in either case, if he qualifies for 769-4A, as the court's well aware. And
Well, I don't want to confuse.
That's fine, Judge.
What I want to do is
that's
keep
what
it,
referring to, though.
I just want to keep it simple. So that domestic violence has nothing to do with these
With the
cases
felonies,
or with
correct,
this
right.
deal. Okay, does that make sense, Mr. Dofer?
Yeah, I guess. I mean, I asked my attorney to come down here and speak with me personally and show me on paper because I wasn't understanding and I still kind of don't. Like now I feel like I'm pleading to something and I'm about to get sentenced to jail time today. You know what I'm saying? He said that we were going to come in here and we're going to try to get the bond reinstated and we were going to try to move forward and like I would have like 3 months to get my life together before maybe sentencing and stuff. Like I'm not really happy with my counsel. He hasn't come down here once to see me. I just feel like I'm just being pushed through the system because there's a lot going on in my cases and whatnot, and I just don't know.
Mhm.
I feel like I don't know. I just feel like I'm being run around.
Mr. Brown, are you representing Mr. Dofer in the domestic violence case as well?
I am representing him in the domestic violence cases, 2 old traffic cases, and 3 FOC cases.
Okay, so I think, Mr. Dofer, we're gonna, I want to make sure that you fully understand everything. And I think what you're asking for doesn't sound unreasonable. And given the fact that you got these cases and then a separate case in a different court, I get
It's on
that
like
you kind of want to.
together. Like it didn't make no sense to me. And I had my fiance call him. He wouldn't call her back. I gave him permission to talk to her. He's just, I don't know. I think I'm going to have to go with different counsel or something. I'm not sure. I like Mr. Brown and everything, but like right now I just don't have the money to hire an attorney. But if I was out on the streets, I would be working my butt off to get it. I'm not really happy with the counsel. I kept telling him like, I don't understand. Can you please fax it to me? My fiance called him. I called him yesterday saying, "Hey, Mr. Brown, please come down here and speak with me in person so I can see it on paper. Like I'm dyslexic. You know, I don't, I didn't really get what I kept asking him. Like we had probably a 20-minute conversation and I kept saying like, I don't understand, but I guess like, if you say this is the best thing, I guess like, I want to get this matter, taken care of and like, I understand like the severity of it and whatnot. It's just, I don't know. I hate to say like I'm an idiot, but I don't understand.
Okay. All right, so we're gonna take a break in your case. When we have a chance, I'm gonna ask Mr. Brown to go down and talk to you here today. And if we can get this straightened out, we can recall your case and we can go forward, okay?
Yes, sir. And I'm sorry for the confusion, Your Honor. It's just I hate to agree to something because like there was no like we hadn't set up like a how much time or anything. Like he's just like I don't know. None of it made sense to me, and it didn't feel right.
Okay. All right, so again, we're gonna stop the hearing on your case. I may try to recall it later. I'm gonna have Mr. Brown come down and talk to you. Is there a
Thanks.
corrections officer there by you?
They're pretty busy. They're doing some booking and stuff.
Okay. Can you ask them to bring Mr. Haley into that room? I'm looking for Michael Haley.
Michael Haley, yes, sir.
Yep, thank you.
Yeah, I think it's going to be a moment.
All right. Hey, Mr. Haley, you may have to press a button there to unmute on your end. There we go. Are you able to hear me okay?
Yes, sir.
Okay. We're on the record in People versus Michael Haley. This is file number 256876. The record should reflect Mr. Haley's present today by video from Otsego County Jail. If I could have counsel put your appearances on.
For the record, Chairman, we're going to the people.
Larry Brown on behalf of Mr. Haley.
All right. Mr. Brown, can you tell me the status of this file?
Yes, Your Honor. I did go see Mr. Haley the other day. I had spoken with him earlier regarding certain things. There's been an offer made in the matter to plead to statute MCL 750.329, which is essentially a person who injures or kills another individual by aiming a weapon intentionally, but without malice. Which I honestly had not heard of that statute, but it is a 15-year maximum. I did review that with Mr. Haley. We are having some very strong disagreements about the way we are viewing the case. The facts of this case are relatively straightforward as far as a lot of the pertinent facts are not going to be disputed at trial. As far as the defense goes, we are just at very strong odds as to how we view these facts and the possible defense. I did review that with him, although he has every right to reject any plea offer, and that is perfectly fine. I will still defend him to the best I can. He does have some issue with me that he wants to change in venue because it's been on the news. He does not think I will properly defend him because I am too buddy-buddy with the prosecutor and working for the state, which I don't, I mean, he may feel that way, but I don't take that seriously. So I would strongly urge him today to consider that, which I did review with in the plea offer. I went over possible consequences and things like that with him as well. But again, that is his decision. And no matter what his decision is, I will defend him the best way I can. So it's going to be up to him if he wants to accept that.
Okay, Mr. Haley, did you wish to proceed to trial in this case, or did you want to accept that plea offer today?
Proceed to trial.
Okay. Mr. Rolla, how much time do the people need to be ready for trial in this matter?
Your Honor, it's set.
Oh, we already have it
Yeah,
set?
we already have a trial date, Judge. And for the record, the offered pledge to offense is the offense of manslaughter, death by weapon aimed with intent but without malice, contrary to MCL 750.329. And it would have made a significant difference in the penalties that the defendant is facing upon a conviction of either murder in the first or second degree.
Okay. All right, I'm just not sure why we had this set for a hearing today.
I think it was a final status.
Final status conference, Judge, in regards to a potential plea, because Mr. Brown wasn't even aware of this particular statute. In fact, I wasn't myself until about 2 months ago. After the last hearing, I did some further research.
Okay.
And then I spoke with the family members of the decedent this morning again on that. And after getting their approval to go ahead with that offer, I extended it to Mr. Brown.
Okay. So we do have trial date set to begin on January 26th, so we'll proceed with trial. We do have the final status conference set for January 20th. Again, that's why I was confused, because we already had the final status conference set.
Judge, I believe the reason for the adjournment was I had noticed the statute last time. I hadn't had an opportunity to discuss it with the decedent's family. So
Okay.
before I could make a formal offer to the defense, Mr. Brown asked the matter be adjourned,
Okay.
as I recall it.
All right, so Mr. Haley, we're going to proceed with your trial as scheduled, which will begin in January. Do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay. All right, thank you. That's all for this hearing today. All right, Ms. Jones, if you want to come forward. Court calls People versus Jones, file number 256900 and 246775. You can come right up to the podium, please. Record should reflect Ms. Jones is present here in the courtroom today. I can have counsel put your appearances on.
Record, John, my phone got people.
Larry Brown on behalf of Ms. Jones.
Mr. Brown, how are we proceeding on these files today?
Your Honor, I'm going to request an adjournment on the violation file. It is directly tied to the current charge. There has been a plea offer on the current charge to plead to possession which I think is the only count, as a habitual second, and the drug double would be dismissed. I have gone over that with Ms. Jones. She is going to request this matter be sent for trial.
Okay, Ms. Jones, is that how you wanted to proceed? So, Mr. Rolla, then how much time do you need to be ready for trial in this case?
Yeah. It's gonna be more on the court schedule than it's gonna be for the
You can
prosecution.
be ready ASAP.
As long as it's not between Thanksgiving and Christmas, I think so, yes, Judge.
All right, Mr. Brown?
Yeah, I don't think it's going to take that long, Your Honor, at the next available date.
Okay, and one day, Mr. Rolla?
Yes, Judge.
Mr. Brown?
Yes.
So we'll set it for a one-day trial. It's going to be 60 to 90 days out. I will set it for a final status conference. So Ms. Jones, we're going to send you two different dates. One will be for your trial date. The other will be for the final status conference. That final status conference will be right before your trial. That'll be the last day to enter into any type of plea. So to the extent that you want to consider any plea offers, that would be the last day to enter into those. Okay. Counsel, if either of you have any motions, that'll be the motion cut off as well. Mr. Brown, are there any other dates I can address for your side?
No, Your Honor, thank you.
Mr. Rolla, any other dates for your side?
No, Your Honor, thank you.
Ms. Jones, do you have any questions about how we're going to proceed?
No.
Okay, thank you. That's all.
We're turning that out 90 days or sub PD.
I will have it set on the same date as the trial date, and so we can address it at that time. Okay, we'll take a short recess. Mr. Brown, you can go talk to Mr. Gopher, let the court know. Okay, Mr. Dofer, are you able to hear me all right?
Yes, sir.
Okay, we're back on the record in Mr. Dofer's files. And Mr. Dofer, did you have a chance to speak with Mr. Brown?
Yes, sir.
All right, was he able to answer the questions that you had regarding the plea agreement?
Yes, sir.
And how did you want to proceed today?
I would like to plead guilty.
Okay. All right, so I had gone through with you the maximum possible penalties for the two charges that you're going to plead guilty to. Did you need me to repeat those?
No, sir.
Okay. Are you currently on any kind of probation or parole?
No, sir.
Okay. So with those maximum possible penalties in mind, how did you want to plead to each of those charges today?
Guilty.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've talked about on the record here today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are actually guilty of each of these charges?
Yes, sir.
So I'm going to talk to you about the oldest charge first, and that's the one involving the metallic knuckles that happened on or about March 12th of 2025. Is that the correct time frame?
I'm not sure, Your Honor. Yes, I would imagine.
If
I don't know
that's what the information says, do you have any reason to doubt that date?
No, sir.
On that date, were you present here in Otsego County?
Yes, sir.
And while you were here in Otsego County, did you possess some metallic knuckles or brass knuckles?
Yes, sir.
Did you have any kind of license or permit to have that weapon in your possession at that time?
No, sir.
All right, and then the next incident happened on August 8th of 2025. That's the one that involves the resisting or obstructing. Do you recall that day?
Yes, sir.
And on that day, were you also here in Otsego County?
Yes, sir.
Did you come into contact with state police troopers at that time?
Yes, sir.
Did you know that that police officer was there performing his duties as a law enforcement officer?
Yes, sir.
All right, and what did you do to resist or obstruct the officer in carrying out his duties at that time?
They told me to get on the ground, and I did not. And I kept asking them where the warrant was, where the warrant was. And I wasn't compliant. I had been drinking. I was scared. I was really confused about what was going on. Where they wanted me to lay down, that's where like I throw my dog feces. It's like in between the side yard. I told them that I wasn't gonna lay down there, that if they backed up, I would respectfully do as they asked. They just kept approaching. The one officer grabbed his gun. I was scared. I just turned around and I started running.
Okay. And those officers were there as part of an investigation at that time, is that correct?
I can only assume, yes, sir.
Okay. Mr. Rolla, are the people satisfied with the factual basis?
As to both files.
Mr. Brown?
Yes, Your Honor, as well as both files.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
On by defense.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Yes, Your Honor.
Mr. Dofer, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. We will set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. In the meantime, somebody from the probation department will be in touch with you to do a pre-sentence report. Mr. Brown, is there anything else you need to address today?
Just briefly, Your Honor, because his bonds were revoked, he has entered a plea in this matter. We would ask the court to consider reinstating his bonds, although I do believe that he still has a bond revocation in the district court as well. He was picked up on a bench warrant back on October 16th, but as far as I know, that is still standing. But we would ask, and I did advise me that, but I did advise, or I would request that the court consider reinstating his bond.
Mr. Rolla?
Leave that to the court's discretion. Now the police know.
All right, given the nature of the plea in this case, and there was one failure to appear, however, given that Mr. Dofer has other matters in district court, and it doesn't look like he had any other issues in this case, so the court will, and there was a bond set, it was set at $50,000 cash or surety. But the court will reinstate the original bond in both files. So if that's been posted, then that should allow Mr. Dofer to be released pending sentencing. Mr. Roll, anything further from your side?
Not in this case, thank you, Judge.
All right, Mr. Dofer, do you have any questions?
And the only thing that I didn't hear is about being charged as an habitual.
I believe that's
It's being
dismissed.
dismissed, Judge, as part of the plea agreement.
Yeah, that was dismissed as part of the plea, so.
All right, thank you.
Okay, all right, that's all for today. The court's going to disconnect at this time. All right.
For you.
Be off the record until 3 o'clock. All right, looks like we have everybody connected, so we'll go on the record in Jones versus Munson. This is file number 2319251. If I could have all counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Jenny Sikorsky on behalf of the plaintiff.
Judge, my name is Mark Gonzago, also on behalf of the plaintiff.
May it please the court, Ralph Valatutti appearing on behalf of the defendants, Kylie, Minor, and one other, Kylie, Minor, and Murphy.
Good afternoon, Your Honor. Jenna Wright Greenman appearing on behalf of Munson Hospital and Munson Healthcare.
All right, thank you. We're on the record here today. Plaintiffs filed a motion to strike defendant Munson's offer to stipulate to entry of judgment pursuant to 2.405. I did have a chance to review the plaintiff's motion in brief along with the supporting authority. I did receive the defendant's joint response. I had a chance to review that, as well as the cases cited by the defendant to the extent that they were different or in addition to those from the plaintiff. Ms. Sikorsky, are you going to be arguing on behalf of plaintiff today?
I will not, Your Honor. Mr. Granzato will be.
Okay, Mr. Granzato, then anything you'd like to present by way of oral argument today?
Well, if you're familiar with the briefing that's been done, I don't want to bore you with it, but I think the most important case is obviously the new case from the Michigan Supreme Court, because the new case involved an offer of an express amount of money to resolve the case, but it was still found not to be in compliance with 2.405. And the Supreme Court's or decision in new specifically said that to be an offer, the offer must propose to stipulate to the entry of a judgment in a sum certain. There is no latitude given in this rule for offers of judgment that culminate in something other than a judgment. And what the defendants have requested here is not just a judgment being entered against Munson, but a dismissal as to 4 other defendants. And that is something that results in the culmination of something other than a judgment. And that's governed by the Supreme Court's decision in new, and that is not in compliance with 2.405.
All right, thank you. Ms. Greenman or Ms. Valatutti, I'm sorry, Ms. Greenman or Mr. Valatutti, anything, it's been a long day. Anything that either of you would like to state in response?
You know, what I'd like to say in response, Your Honor, is I respectfully disagree with Mr. Granzato's argument of the application of the new case. As we indicated in our response briefing, I believe the new case is wholly different. There were parameters in that case that the court found were considered stipulations and therefore did not make it a true offer of judgment per MCR 2.405A. In this case, our offer of judgment complied with all of the requirements of the court rule. There was an offer to enter a judgment for a sum certain against Munson Hospital. It indicated, yes, that would mean it was on behalf of Munson Hospital and dismissal of the individual named defendants. But that didn't change the terms of the sum certain, which is differentiated from, I think, Mr. Granzato's citation of the new case. In this respect, we feel that this case, not only is it premature for plaintiff to, in my opinion, file this motion for a motion to strike, but it's wholly inapplicable to what was offered here. It was an offer of judgment, good faith, to resolve the matter. As you know, as trial was pending more acutely at the time than now, and it was for a sum certain. You know, that was on behalf of Munson Hospital. The fact that it was made on behalf of Munson Hospital, and that was simply literally stated, and therefore it would mean that the individual defendants would be dismissed, is not some sort of caveat or predicate as plaintiff is trying to argue to this court.
Thank you. Mr. Valtutti, anything you wanted to add to that?
Just this, Your Honor. First of all, the new case is spelled K-N, E something, not N-E-W. And I know that.
No, I know. I read it. I'm aware. Yeah.
Okay. So that is also a post-verdict case. The doctors in this case, they don't have any money. And so the hospital cannot really make an offer of judgment without getting a dismissal of the doctors. And the purpose of the statute, the purpose of the rule is to encourage settlement. And we did so, or the hospital did so by offering up the money which the court is aware of, $2.2 million, which does have raised judicata effect for the hospital. The doctors simply can't because they don't have any money.
So I have a question, and maybe this is naive or just not savvy in terms of how hospitals and doctors make offers of settlement in medical malpractice cases, but it does seem that the law is a little bit unsettled in this area. I don't think any of the cases cited by anybody are directly on point with exactly the offer that was made in this case. And I couldn't find any cases. I thought all counsel did a good job of kind of tracking down any cases that would be relevant. I wasn't able to find any on my own. But Mr. Valtutti and Ms. Greenman, I mean, couldn't we solve this entire problem if the doctors simply joined in with Munson in the offer to stipulate to judgment, knowing that, you know, maybe the money isn't going to come from the doctors, it's going to come from the hospital. But if the doctors join in that offer, then doesn't that eliminate the problem here? And can't Munson still, you know, if it was accepted by the plaintiffs, still pay it? And so the doctors aren't necessarily on the hook, I guess. That would have to be a matter between the doctors and the hospital. But wouldn't that solve our problem? I'll just throw that out to either of you if you want to answer that.
I could answer it on behalf of the doctors, Your Honor. It would solve a problem insofar as the issue is concerned, but it would create a problem for the doctors because they would then be reported to the data bank as being associated with a large settlement. And that is a big problem for doctors, and not one that they would just wink at. I can assure you of that. I can also tell you that in more than 90% of these settlements where the hospital is vicariously responsible for the doctors and the doctors don't have policies of their own, that the predicate for settlement is usually that the dismissal be entered with for no cause of action on the doctor's behalf, and then the case is settled and the money is paid on behalf of the hospital. And that would certainly be that's the intent of this offer to stipulate to an entry of judgment in this case. Why, if here, you know, at time of verdict, there's a lot of the questions are taken out. For example, let's say the doctors all get no causes, then plaintiff's failure to respond to the hospital's offer would have a different look to the court than a case in which all of them were hit for a large amount of money. And I think that's why 405 has to be read as a complete rule with all of the subparts and not broken up into individual parts and then acted on the basis of an individual part. I don't think there's any case where this determination has been made that they would strike an offer of judgment pre-verdict. Obviously, the plaintiff doesn't want to pay costs, but if they don't want to pay costs, they ought to consider the chance of losing the case, and maybe they would have a different view of what they should counter offer or what they should demand in response to such. These rules have been changed over time. I have to tell you, we used to have mediation that had sanctions. We have this offer of judgment rule. It's all these rules were designed to encourage settlements, which I think are good. the Supreme Court in its wisdom did away with the sanctions applicable to mediation. And this, as Mr. Gonzato, who is an excellent lawyer, would argue it, the meaning of the rule would be lost, because you would, if you had multiple defendants all claiming entitlement to coverage under one policy, you would be hard pressed to ever use this rule as a means of trying to move the ball forward to get it settled. So I think that all of those factors should be taken into consideration. I mean, the purpose of the rule was not a bad purpose. It would serve to promote settlement. The purpose of sanctions on media after mediation evaluation by experienced people who are involved in this industry, this business, this practice of law, judges, lawyers, and the professionals who are involved in it, with the sanctions, would cause people to seriously consider settlement before trial. That was preferred. I think this new idea, and I see it often.
But Mr. Valatutti, I hate to cut you off, but I think we're getting outside the scope of argument on this motion. So I appreciate your thoughts on that, but is there anything else you wanted to add from a legal standpoint?
From a legal standpoint, trial of a case without repercussion only occurs on the plaintiff's side.
Okay, thank you. As to my question, and I appreciate your answer, Mr. Valatutti, it sounds like there's consequences to the doctors that outside of monetary that maybe I wasn't aware of. And so that does answer my question. Ms. Greenman, is there anything you wanted to add to my question or that point?
No, I echo that. The reality is if they were to join in, it does seem like a simple solution that we could all have. However, then that would be recorded, right? As those physicians would be part of the judgment, whether they had money to contribute or not. And under federal Stark laws, they have to be reported to the National Data Bank. Here, this was simply, like I said, putting out there, which the plaintiff already knows, they would not be paying for a settlement. It would be Munson. That was the sum certain that was offered as the offer of judgment, with the proviso, like we do before settlement, that, the individual physicians would be dismissed.
Thank you. Okay, Mr. Granzato, it's your motion. I'll give you the last word here. Anything in response?
If I may, Judge, on the issue of prematurity, if you're interested in that, the fact is that you have everything you need to decide this now. And this is unlike some other aspects of medical malpractice litigation, in that there can be things done in this case based on your ruling on this motion between now and a verdict, because there could be another round of offers of judgment made, depending on how you rule on this motion. So this motion is not premature, precisely because not only do you have all the information you need, you may not have all the case law you'd like to have, but you have all the information you need to make a ruling on my motion. But it can also make a difference between what the parties do between now and trial. That's a point that I think needs to be made. Other than that, I think we're guided by the new case in the Supreme Court. And I think the new case dictates that this motion be granted. Thank you.
All right, thank you. So again, I did have a chance to review the arguments of the parties prior to the hearing today, as well as the law that was cited. And, I think there's a good argument to be made that the motion is premature. The cases that I read all involved courts after a verdict trying to determine whether or not sanctions would be appropriate or costs would be appropriate based on the offers that were made prior to trial. None of them were in the context of a motion to strike, is what we're dealing with here. But I also think that Mr. Granzato makes a good argument that a ruling on the merits at this time as to whether or not this is a valid offer would and can make a difference to the parties in terms of how they proceed forward in negotiating and, their decision making going forward. So I think even if it is premature, I don't think the court would be precluded from ruling on it, on its merits at this time. And I do think the new case is the case that is controlling. It's the one that I feel is the closest in terms of the fact pattern to what we have here, although it isn't directly on point. And what we have here, I think, is quite different than what the court was looking at in the new case, where the plaintiffs had offered to pay an amount, $3,000 to the defendants, then the defendants would convey that property the property in question by quitclaim deed to the plaintiffs, where there were things of value going both ways in that offer. And when I say value, I mean more than just the dismissal of a party, which is what we have in this case. And Mr. Granzato quoted what I wrote down as being the controlling language of the court in that case, and that is that 2.405 offers no latitude for offers that result or culminate in something other than a judgment for a sum certain. And so looking at, I think, a close reading of that language, in my view, is that if the offer is going to result in something other than a judgment for a sum certain, so it could be, as in the new case, money going one way, a conveyance of property going another way, that's something other than a sum certain. In this case, we do have an offer that would culminate in a judgment for a sum certain, and that is the offer that was made by Munson. Now, because there is also an added, I don't know if you want to say condition or stipulation, that the doctors be dismissed as part of it, to me, that doesn't take it out of the realm of a judgment for some certain. It doesn't change the character of the ultimate resolution of the case. It just means a complete resolution, or would mean a complete resolution of the case, with all parties being out of the case at that point. Whereas the new case did involve a resolution or a result in something that was other than a judgment for a sum certain. So I think the difference here to me is the conveyance between this and the new cases. In the new case, that conveyance of property in exchange for payment of money, to me, is different than a sum certain offer, with the proviso that that the rest of the defendants be dismissed and the case is over. And that's where I kind of differ with the plaintiff's argument and their statement in their brief, which is that any offer that is conditional in character, and I'm quoting right from plaintiff's brief, is not allowed under 2.405. That's a statement that the plaintiffs made, and I don't think that's backed up by the new case necessarily. I think that's a broader statement than what the new court found. So in my view, this is a proper offer under 2.405. I don't think there's a basis to have it stricken at this point. I do think that it could be the basis for the imposition of costs post-trial. So for those reasons, the court will deny the plaintiff's motion. Mr. Granzato, as the moving party, I would just request that you prepare an order that reflects the ruling of the court today for the reasons stated on the record, and either submit that with stipulation as to form from opposing counsel or under the 7-day rule.
Fine. Thank you.
Okay. All right. Thank you. That's all for today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes our afternoon docket. Court will be